Welcome everybody to today's Lunch and Learn webinar. Just before we get underway, just a bit of housekeeping. If you have any issues during today's webinar, please pop them in the Q&A box, and either myself or my colleague Anna will help you out with those. Also, if you have any questions during the webinar, please pop them in the Q&A box and we can answer them at the end of the webinar. You've been informed we can't do anything any questions that are case specific. But if you do have any questions about the process and any general questions, then please do pop them in the Q&A and we can go through those at the end. So I'm pleased to introduce Veya, who joined the RCVS in early 2017, having previously worked in management positions at the Chartered Institute of Management Accountants, the Chartered Institute of Arbitrators, and the General Osteopathic Council. She first graduated from University of Cambridge before qualifying as a solicitor in the city. I'm also pleased to introduce Gemma, who studied at University College London and Leeds Metropolitan University before qualifying as a solicitor and working as a criminal defence lawyer, joining the RCVS in 2014. So over to you, Veya.
Thank you very much. And just to add to that, Gemma has been at the RCVS for about 4 years, and she leads a team of case managers whose main task is to assess and investigate cases at the early stages. As we've said, I joined the RCVS last year, and I lead the professional conduct team as a whole, which includes Gemma and her team, but also the solicitors who deal with cases in their later stages, and the chief investigator. So we're aiming to cover a number of topics today, with the broad aim of demystifying the process from your perspective. We'll talk about the why and the how of regulation, what kind of concerns the RCVS can deal with, what disgraceful conduct in a professional respect means, and the common causes of concerns. We'll also talk through the different stages of the concerns process and how we deal with concerns where it emerges that there are issues with the health of the vet or the veterinary nurse who's been complained about. And hopefully at the end there will be some time for questions. So the why and how of regulation. It's the fundamental role of the RCVS to safeguard animal health and welfare and act in the public interest. And regulation of vets and veterinary nurses is part of how we do that. So there are different aspects to regulation, and these include setting standards of education and training and providing for continuing professional development. It includes publishing a code of professional conduct and, of course, having a system of dealing with concerns about the professional conduct of vets and vet nurses. Importantly also, the RCVS maintains the register of vets and vet nurses so that anyone consulting a registered veterinary professional will know that they have reached the requisite standard of training and have committed to abiding by the code of conduct. So regulation of professionals, and we should remember that most professionals nowadays, including doctors, nurses, dentists, solicitors, are regulated, is sometimes seen as a burden on them. But you can also say that regulation provides benefits to the professional, and I've mentioned a few here. First of all, it can help to promote public confidence in the profession as a whole so that owners do seek treatment for their animals. Secondly, the Code of Conduct lays down consistent standards of conduct for all veterinary professionals and gives clarity on what's expected. And thirdly, a formal system of investigation ensures that only those who are fit to practice can do so. And it may help to bring an end to the complaints where an owner doesn't accept the practice's explanation of a situation which has gone to plan for them, and provide some kind of finality in those situations. Okay, that's an overview of regulation and why. We can only deal with the most serious concerns, and those are complaints which are capable of leading to a vet or vet nurse's removal from the register In other words, the most serious kinds of concerns. And this could include criminal convictions which might render the vet or vet nurse unfit to practice. And if you look on the RCVS website concerns page, you can see some recent cases which have arisen from convictions. It also includes complaints, those complaints which might lead to a finding of disgraceful conduct in a professional respect. And these might arise from exceptionally poor professional performance, dishonesty, and potentially very serious concerns where health may have been a factor. And I'll talk a bit about that later on. The context in which any of those kinds of serious concerns might arise is very wide-ranging, but we do see a few common issues which crop up regularly, and I've mentioned them here. The first one is communication, which of course overlaps with the second issue, which is consent. And for example, we often see a gap in between what the vet has said or thought they've said and what the owner has heard or taken in. And in the same vein, what the practice thinks they have consent to do and what the owner thinks they've consented to. And the RCVS has recently issued updated guidance on communication and consent, and I would encourage you to have a look at that. You can find a link to the website, link to the update on the news pages on the website. Complaints about adequate and appropriate care are also commonly made, and here I would say that while an unhappy outcome may be what's driving the complainant, the RCVS will be looking at the care which was actually provided and whether it was reasonable in the circumstances, notwithstanding the outcome. So to sum up, disgraceful conduct in a professional respect, or serious professional misconduct as it's often called, and we often call it that, is only going to be found in the most serious cases. And this is where the conduct falls far below what's expected. We're very clear that negligence is not equivalent to disgraceful conduct. So as I've said, disgraceful conduct is conduct which falls far below the standard expected, and negligence might be conduct which falls below, so not far below the standard expected. And it's also very clear, and we're very clear, that in clinical cases, only in exceptional circumstances is a single error likely to amount to misconduct. And that's what we might term jaw-droppingly bad mistakes or performance. And just to sum up, we look at disgraceful conduct in a professional respect, but there are some things that we know we can't do, and investigations can't result in fines, orders to carry out additional treatment, orders to apologise, orders to refund fees or pay compensation, or determinations on alleged negligence. And now I'm going to hand over to Gemma to talk about that, and then the RCVS complaints process itself.
So in the past, the college has received large numbers of concerns which were not matters that could amount to serious professional misconduct. They were inappropriate for the college to deal with and didn't fall within their remit. But people came to the college because they had nowhere else to go. Initially, a trial alternative dispute resolution scheme was set up that was a straightforward dispute resolution scheme. That has now changed to a mediation service which has been made permanent. It's called the Veterinary Client Mediation Service. It's operated by a firm of solicitors on our behalf. It acts, as the name infers, as a mediation service. They act as a go-between between clients and their practices where there are sources of dispute or dissent. Referrals can be made by both sides, by both veterinary practices and by clients, but of course it is voluntary on both sides. Nobody can be compelled to engage in mediation. The VCMS will also insist that any client who wants their matter to be considered needs to go through the practice's own complaints procedure initially. As far as the RCVS is concerned, this means that we now have a sort of triaging process in relation to matters that are brought to us. The concerns form is not available online, but there is a sort of preliminary inquiry form that can be completed. That, coupled with emails and telephone calls to the department, are all considered by individual case managers who will discuss matters with the clients and try to identify what the issues are. Again, we will generally encourage people to try to raise the matter with their veterinary practice or their veterinary surgeon to see if issues can be sorted out between the parties. And if we feel that it is never going to amount to serious professional misconduct, or there are no issues that would appear to be have the potential to be serious professional misconduct, then we will refer members of the public to the VCMS as a more appropriate way of dealing with their problems. So if they're looking for example, a refund, or they think that there should be a goodwill gesture, or the fees should be reduced, or they're sometimes simply looking for an apology or even an explanation, those are matters that in general terms will be referred to the mediation service unless there is anything that we can flag up as having the potential to be of greater seriousness. Once that triaging process has taken place, if we identify matters which could amount to serious professional misconduct, then complainants are asked to fill out our concerns form, and the matter will pass to stage 1 of the process. We have a statutory obligation to consider concerns that are raised with us. There are occasions where people will still decide that they want to raise matters with us even after receiving advice, and those cases will be considered in due course. Stage 1 is the KPI, the aim is to deal with these matters within 4 months. Now that's 4 months to either closure or to referral to stage 2. At the moment, the vast majority of cases are being meeting those targets, although clearly there are circumstances in which that is simply not possible, simply because of the complexity or the number of people involved, or for various other reasons. We are keenly aware that we only ever receive one side of any incident when matters are brought to our attention by a member of the public. We need to obtain information from both sides in order to be able to assess the situation properly. We do know that this can be very stressful for those on the receiving end of these concerns, but it is vital that we obtain sufficient information to ascertain what the situation is. And it's quite often the case that we can resolve these matters thereafter. There can be a feeling among respondents that they are deemed to be guilty until they have proven themselves innocent. That is not the case. We do appreciate it might feel like that, but that is not the case. We cannot know what has happened without the input of the respondent and other members of staff or individuals who may have been involved. And the only way we can get that information is by approaching people and asking them to provide their side of the events. The matter is passed to a case examiner group, and there is an initial consideration which is carried out by the case examiner group. I will go on to explain who those people are in a second. Issues that could amount to serious professional misconduct, if they are identified, will result in concerns being raised with the respondent, and the information that's been received from the complainant will be sent to the respondent, and they will be asked to comment, possibly in general, but also on the specific conduct issues that have been identified. There are often lots of other matters that complainants are concerned about, and we will try to focus on the issues that we think could have the potential to amount to misconduct. As I've mentioned before, we are working on the basis of what the complainant has given us, and therefore sometimes this can be misrepresentative. But again, it's important that we obtain as much information as possible to obtain a full picture. We request clinical records, we request telephone recordings if they're available, we request accounts from other people who may have been involved, for example, administrative staff, receptionists, or veterinary nurses. If you are contacted by a case manager, you will be given their contact details. The case managers are always happy to discuss matters with you, either in person or either by telephone or by email. And there is support also available to you from your indemnity insurers. We would always encourage people, veterinary surgeons, to discuss matters with their employers, which can be a source of additional support, although ordinarily we will not disclose concerns unless we need help in identifying those who've been involved. There is also a support service called Vet Life, which Valia will address further, who can provide support to people who are in these situations. The case managers are employed by the RCVS. Some are legally qualified, others are simply experienced in the field. There are 6 of us at the moment, one of whom is part-time. The case examiners are members of the Preliminary Investigation Committee. There are 6 veterinary surgeons and 3 lay people on the committee, and each case examiner group is made up of 1 case manager, 1 veterinary case examiner, and 1 lay case examiner. The decision needs to be unanimous between the 3 of them as to whether a matter can close or needs to be progressed further, and all 3 enter their views and their contribution as a paper exercise. All the information is considered by all 3 and a decision is made by all of them. The task for the case examiner group is to determine whether there is an arguable case of serious professional misconduct on the part of any veterinary surgeon or veterinary nurse. This means that if the matters as alleged could amount to serious professional misconduct, and there is an arguable case that that may be true, if there is incontestable evidence that could contradict the complainant's account, then the matter will close at that point. As an example, if a complainant alleged that they had taken their cat to the vet to have its nails clipped, and whilst under anaesthetic the veterinary surgeon had spayed the cat without their consent, on the face of it that would be a proceeding without consent. If, however, in response to those allegations, the veterinary surgeon came back and provided a signed consent form, statements from witnesses detailing the point at which consent was given to a spay, and telephone recordings during which the complainant had phoned up and booked the cat in for a spay, clearly that would be incontestable evidence to the contrary, and the matter would close as there being no arguable case. That obviously is an example and a fairly stark one, but every case turns on its own merits, and that's simply an illustrative attempt. It is a relatively low threshold, so if there are matters in contest, then the matter will need to be forwarded to the Preliminary Investigation Committee. Alternatively, if the case can be closed, then it will be closed at that point. That's if there is no arguable case. It can either be closed outright, or it can be closed with advice given to the practitioner. This is, in essence, cases where there are elements that might not amount to serious professional misconduct, but that nonetheless there's a view that the practitioners have fallen short in some way, or that the standards have not been entirely adhered to. Advice is ordinarily a reminder to adhere to the code of conduct and the supporting guidance. Common forms of advice are to ensure that fully informed consent, or that communication is clear. Keeping detailed clinical records is another one that quite commonly comes up. Addressing complainants' concerns and complaints in a timely and prompt manner is another one that frequently comes to light. If the case is closed at that point, then a detailed letter will be sent to the complainant and to the veterinary surgeon, outlining the information that's been presented on both sides and the reasons why the CEG has made the decision at that point. Complainants and veterinary surgeons have the right to request a review of that decision if they think that there has been a significant error made or there is further information that has not been considered. That review needs to be requested in writing within 28 days and would mean that the matter would be forwarded to the head of professional conduct and the chair of the PIC for further consideration. If a matter doesn't close at stage 1, then it will be referred on to a meeting of the Preliminary Investigation Committee. Excuse me. You can see there the KPIs, the timeframes for matters to be completed by the Preliminary Investigation Committee, and the tests that need to be met. The Preliminary Investigation Committee is, as I mentioned earlier, the people who sit as case examiners also are members of the PIC. There are 6 veterinary surgeons on the PIC, 3 small animal vets, 1 equine vet, 1 large animal vet, and 1 veterinary surgeon whose experience is predominantly in public health. The biographies of those who sit on the PIC can be found on our website. The PIC sits every 2 weeks, roughly. At the moment, it's sitting with a representative number of the members. So there are 3 veterinary members, including the chair, and 2 lay members. That's ordinarily the makeup of a meeting. All the information in relation to the matters is placed before the committee for consideration. If a matter is referred to the PIC, then all the respondents involved will be asked to provide copies of their CPD record and proof of their public public indemnity insurance cover. This is not any form of victimising, it's simply something that is asked of all respondents who are, whose matters have passed to the PIC. The committee discusses matters in detail and reaches a collective decision. The task for the PIC is to decide whether there is a realistic prospect of a finding of serious professional misconduct. Now that's whether there is a realistic prospect of the facts being proven, or of those facts amounting to serious professional misconduct. And then by stating a realistic prospect, there needs to be a genuine possibility that those matters would be proved. This means, because that is a much higher threshold, that matters that are passed on from the case examiner group on the basis that they are arguable can quite often close on the basis that while arguable, there is no realistic prospect that they will go any further. So cases that go up to PIC frequently close at that point. The other factor that needs to be considered by the committee is whether it is in the public interests to progress the matter to a meeting of the disciplinary committee. Those factors, of course, include things like whether it is a one-off incident, whether there are circumstances that are so unlikely to be repeated that it's not really an issue. And in order to establish this, the committee can adjourn the matter for further information. It can refer the matter to external solicitors, and it can effectively gather as much information as it feels necessary in order to make a fully informed decision. The possible outcomes from the PIC are, if there is no realistic prospect, it can be closed either with or without advice, and that draws a line underneath it. It can be held open, which would mean that it would be held open for a given period, usually with advice and often with a request for a practitioner to do something, for example, a communications course or to carry out some relevant CPD. Sometimes it can be held open whilst visits take place to address, for example, record keeping matters or issues that have been identified. A held open case is usually a matter that could amount to a realistic prospect of serious professional misconduct. but that it's not appropriate to refer at that time. Examples would be a single incident, or a matter that is simply not in the public interest to refer at that point. If a matter of a similar nature is brought to light during the period of the held open phase, then the held open matter can be reconsidered at that time. Again, if a matter is decided at that point, then a request for review can be made, but I'll pass you back over to Velia, who will address those matters further.
Thank you. So I just wanted to mention here what rights the parties might have to challenge a decision of the case examiner group or preliminary investigation committee which they're not happy with. And as Gemma has said, that could include a review. So we do encourage whoever has expressed unhappiness first to contact their case manager, as in fact a further explanation about the reasons for the decision might be all that's needed. However, if they do want the decision formally reviewed, then the chair of the PIC and I, in my role as head of professional conduct, will look again at the complaint and the information that's been provided. And what our task is to consider whether there's been a significant error in the decision reached, or whether any new evidence which the complainant or the veterinary professional has presented would affect the outcome. And to give you just an idea of the outcomes of the review process, I would say that 9 times out of 10, it's the complainant who requests the review. And also in 9 cases out of 10, there's no change to the decision reached by the CEG or PIC. And finally, for completeness, in terms of challenges to a decision at CEG or PIC stage, I mentioned judicial review, and that's a remedy which would be mainly available to a complainant who disputes the closure of a case even after a review's taken place. It requires an application to court by the person wanting a judicial review, and it's therefore not to be undertaken lightly, and so is in fact quite a rare occurrence in terms of challenges to the CEG or PIC decisions. Right, moving back into the main process, we're on to stage 3, which is the disciplinary committee. The aim there is to hold hearings within 12 months of the complaint originally having been registered. And what I want to say here is that it's important to note that in fact very few cases do proceed to the disciplinary committee. And in 2017, so that's last year, where there were probably a higher number than usual of cases referred to the DC, still no more than 3% of cases were referred, which means that in fact in 97% of cases, or 97% of cases closed at CEG or PIC stages. So it really is quite rare for a case to go as far as the disciplinary committee. Just to give you a few facts about the DC here. Now, there's a slight difference between what happens with nurses and veterinary surgeons, and the vet nurse DC sits with 3 members, whereas the veterinary surgeon DC has a total of 18 members, but in practice 5 to 7 of them will be present for a hearing, and the minimum number is 5. The committee has a mix of veterinary members and lay members, and lay members are those people who've got no veterinary qualification, but they represent the public interest and bring a non-professional perspective to the decision making. All DC members are independently appointed, and that includes having external independent interviewers. Hearings are normally held in public. There might be exceptions if there's information which is deemed highly sensitive or personal, and health issues or issues relating to children might be included in that. there's a three-stage process to the DC's decision making, and the first thing that they consider is whether the facts alleged against the respondent have been proved, then whether they amount to misconduct, and then finally, if the proven facts do amount to misconduct, they consider what the sanction should be. So we've talked a lot about serious professional misconduct during the course of this webinar. And looking at the middle stage, which is whether the facts do amount to misconduct, that's the middle stage of the DC's decision making. The standard expected of a veterinary professional is usually identified by reference to the Code of Professional Conduct, but bear in mind that not every breach of the code is going to amount to misconduct, and the Disciplinary Committee are very clear that the question of whether something is or isn't misconduct is a judgment for them. So we've had cases where the veterinary professional has said, yes, I admit the facts and I also admit that these amount to misconduct. And the Disciplinary Committee has said, well, that decision about whether it's misconduct or not is for us, not for you to say. So, as I've said, it could be that the DC find all the facts proved, but still find that the facts don't amount to serious professional misconduct. But assuming that they do find that there's serious professional misconduct, they've got a number of options. First of all, they could decide to take no further action. Secondly, they could decide to give a reprimand or a formal warning. They could also decide to suspend the veterinary professional for up to 2 years. And finally, and the most severe sanction, of course, would be removal from the register. And where a vet has been removed from the register, they do have a right to apply for restoration following a minimum period of 10 months. And they can also decide that a registrant should be referred to the health protocol. And I'm going to talk a little bit more about that in just a minute. And again, for completeness, I just wanted to mention that where a vet has been suspended or removed from the register, they can appeal to the courts. In fact, it's the Privy Council against that decision, and that has happened in the past. So I've mentioned the health protocol a couple of times in this talk, and I want to give a little bit more information about it now. The RCVS can't deal with cases where the health concern is the originating issue. And what I mean by that is that, unlike some health regulators, ill health is not on its own enough to amount to a concern which the RCVS can investigate. However, we do have cases where there's been a concern about the conduct of a vet or a vet nurse, or where we're notified of a conviction, where on further investigation it appears that ill health, and this could include addictions and mental health problems, and in fact often does include those, lies behind the conduct or conviction. In these cases, and only where the case is so serious that it might be referred to the Disciplinary Committee, the PIC can, as an alternative to referring to the DC, seek to manage the concern through its health protocol. And this usually involves the respondent giving a number of undertakings, which might include refraining from practice for a while, agreeing to seek treatment, and where relevant, agreeing to abstinence if there's been a drug or alcohol problem identified. And as I've just mentioned, the DC can also use the health protocol as an alternative to a sanction. I've also mentioned on this slide the performance protocol, and again this can be used by the PIC as an alternative to a disciplinary hearing, and in such cases the PIC will ask the respondent to give undertakings aimed at improving their clinical performance. And as I've said on the slide, the RCVS is not here to punish respondents in a concerns process, and we consider the health and performance protocols, protocol in particular, to be a more effective and compassionate way of dealing with the underlying problem. So Jem has already mentioned a few sources of support and advice, but I would say that as a team, we are constantly striving to make our communications with both professionals and those who've raised a complaint more effective and understandable. But we do know that when a concern is raised, it can be a source of great stress to the vet or vet nurse. And on this slide, I just mention a couple of sources of support and advice. The first one, of course, is Vet Life, and we will send out a leaflet from Vet Life, which actually has been devised by and designed by Vet Life themselves to focus on what they think would be helpful to the vet or vet nurse in these situations. You can, of course, also contact your professional indemnity insurer. And as Gemma said, we do encourage you to inform your employer if that's appropriate. We don't automatically disclose the complaint to your employer, but we do encourage you to let them know if you think that's appropriate. And as Gemma has also mentioned, it can be a good idea to let others in the practice know, because apart from supporting you emotionally, they can be a good source of practical support. For example, just by helping you to locate documents or clinical records which may assist in the investigation. So that's all that we wanted to say, but I think we've got time for some questions.
Yeah, that was a brilliant webinar. Thanks very much, ladies. That was really informative. If anyone has any questions, please pop them in the Q&A box and we'll put them to your presenters now while we have time. Yeah, Felipe did put a question in there a little while ago, but I think you just covered it about professional insurance helping with, in the case of a complaint from a client.
Yeah.
I think
Does that cover his question?
I think so, yeah. He was just asking the professional insurance that he has to pay for as a vet surgeon practice in the UK. Could that help with a complaint from a client if we do the best to stay within the laws?
Yeah, I think most indemnity insurers do include disciplinary proceedings as part of their cover. I know certainly the Veterinary Defence Service are the one who provide the most, and I think provide cover for most people, and I think they definitely do. So,
is that worth checking their policies though, just to make sure?
If you're covered by anybody other than the VDS, and I think those people are few and far between, but I think they are. It is worth checking.
Brilliant. Last couple of seconds, if anyone's got a question to put in. Like I said at the beginning, we can't do anything that is case specific, but if something is regarding the process or anything, we can put that too. Let's have a little look. Some questions have come in. There's a couple that come in just regarding cases, but as a general question, about the notification when a complaint comes in, whether it goes to the person who's had the complaint against them or an employer, just to confirm that for some people who've had that experience in the past.
If we can identify the person who is being complained about, then obviously we will go straight to them. There are occasions where people raise concerns about a practice per se, and in which case it can be difficult for us to know who exactly was involved, and therefore we will ordinarily contact the senior veterinary surgeon at the practice and ask them to assist. There are cases also where if there is seen to be not the actions of any one individual, but a practice issue, then sometimes that will need to be directed to a senior veterinary surgeon at the practice, rather than, because we don't have named individuals. But in general terms, if we can identify those who are involved, then they will be the ones who are contacted.
Brilliant. Bit of clarity there, great. Andrew's asked about recording telephone calls that you mentioned. He's asked if it's commonplace, and he said, is it legal without notice?
I can't necessarily advise on the legality of it, but it's a fair few veterinary practices do record calls. I think you probably need to make it clear to people phoning in that calls may be recorded, just as you often hear if you phone an institution, they will tell you that. But yes, it is. There are a number of practices that do record calls.
Yeah. And if any practice is concerned about whether it's legal or not, they should obviously take their own legal advice about that. But as Gemma said, it's not uncommon and can sometimes be helpful.
Brilliant. Usually if you do have a provider who can record the phone calls for you, they can obviously help with advice, and usually set up like you do here when you phone up. There's usually a notice at the beginning as well. So yeah, if you do have a provider who does that, speak to them as well. Roman said, is there any chance of vet surgeon's PIN code being taken away at stages 1 and 2, or only at stage 3?
I assume that by PIN code, Roman means their right to practice. So I'm just going to answer it as if it's that. So no, a vet can't be suspended or removed and thus not able to practice at stage 1 or 2, only following a DC. So if that wasn't the question, then let me know. But otherwise, assuming it was, only at stage 3 can a vet's right to practice be removed.
Great. Someone else has asked, how long after a complaint is made do the nurse or the vet informed about it?
Well, at the moment, we ordinarily contact them as soon as we have managed to identify whether there are any conduct issues that we need a response on, or alternatively, they are simply contacted after the event to be told that we've considered these matters and we have decided to close the case. As you may well be aware, the general data protection rules are coming in next month, and I think we will need to change our processes, because people will need to be notified within a short period of the information being passed to us. So that, I think, will change. But at the moment, it is simply as soon as we can practically contact them and raise any issues that need to be raised, or alternatively, as soon as a decision has been made not to progress the matter, then they will be notified thereafter.
Brilliant. Ian said there's a great deal of concern about the time cases take to resolve. What can be done and what is being done to speed this up, please?
Well, cases at stage 1 are now, the vast majority of those cases are now being concluded, and that means either closed or referred to the PIC within 4 months. Then when they're considered at PIC, again, they are often closed and decided relatively quickly, so that might be within about 5 to 6 months from registration of complaint. But there are some more complicated cases, and they're relatively few, which do take longer, because we aim to do a thorough investigation at that point. But we are constantly striving as a team to improve the timeliness of our investigations, without losing the quality and fairness and thoroughness of an investigation. But as a general point, I would say that we do know that the longer that case remains in the system, the more stressful it is. So we do have that very much on our minds as we go about our work.
Excellent. And another question's come in, just saying, how would you handle a case in which practice protocols have affected patient welfare, but the complaint is lodged against a particular member of staff?
Yes, I mean, this, I recognise the situation. We do try to unpick in those situations what has actually happened, and the extent to which any particular member of staff might have been involved. it's not straightforward. So what I would say is we do try to unpick it. There is guidance actually in the supporting guidance about an individual vet's responsibility in such situations, and vets and vet nurses do remain individually responsible for what happens in the care that they give. But as I said, we do try and unravel the particular situation which has arisen.
Brilliant. Thanks very much. I think that's all the questions we've got. You've answered very thoroughly. Thank you very much. Thanks for everyone attending today's Lunch and Learn, and we'll see you all on another webinar soon. Thanks. Bye-bye.